Senator Kombowe Friday Benson, representing Bayelsa Central Senatorial District. Mr. President, sometime on the 10th of May 2016, while addressing an audience, the Prime Minister of the United Kingdom made a very open declaration about Nigeria and Nigerians. That Nigerians are fantastically corrupt, distinguishing nobody, excluding nobody. The statement was so clear that Nigerians and Afghanistan, these two countries are the most corrupt countries in the whole world. And here we are. Sir, I want our very distinguished acting Chief Justice of the Federation to help us to explain those who David Cameron were actually referring to. Are they here? Which of them are the corrupt Nigerians? Are the senators corrupt? Is the judiciary corrupt? Which of them, which of the Nigerians is David Cameron referring to? Mr. President, sir, are we expecting a corruption-free moment and period of our reign in Nigeria? That is my question, sir.
Recognize me. My name is Senator Abdul Ningi, and I represent Bauchi, Central of Bauchi State. Let me join Mr. President in welcoming you and our Lordship to this very august chamber, and further congratulate you for this very, very special nomination. I recall seeing you in the confirmation of Justice Mohammed Tanko and Justice Ariola. You accompanied both of them. And one of the highlights of those two sessions was the issue that was raised by Senator Kwaka, SAN, on the issue of the ex parte order and the assurances we had there received by their Lordship doing something about it. These ex parte orders, my Lord, has become a tsunami in Nigeria, and therefore some of us begin to wonder how easy are these orders assessed. I can tell you straight that 6 years ago, Your Lordship, I had the opportunity of visiting a political friend in his office, and he opened his box and brought 5 ex parte orders in advance. Ex parte orders in advance, and from a competent court of jurisdiction in this country. And it makes me wonder how that is possible. And you could see within the last, by the time I met him, he was using these ex parte orders. All they were doing was to fill in the gap, fill in the dates. And he has assessed these ex parte orders in anticipation of possible problems by political opponents. And believe me, my Lordship, those orders succeeded at the end of the day. Now, the question that I would like to ask you, is the hand of the judiciary tight in the possibility of not meting out sanction? Or do you need an intervention of legislation in making sure that such irresponsibility is actually made by a law of the National Assembly, making sure that it's criminalized? What's your opinion about it? I know, as a fact, you made mention of the necessity of this ex parte order, but you can see clearly it doesn't work in this country. People have these orders left, right, and center. People are trying to block road of justice at every given time. And I want during your tenure, so that by the time the next justice is coming before the Senate, this question may not arise. But these two justices, they assured us something will be done, and actually nothing serious is being done about this matter. Please, I want you to comment. Thank you.
Aliu Oshomole. I represent the good people of Edo North from Edo State, where my Lord, the acting Chief Judge, did an NYSC. Like everybody has said, sir, no one will look at this CV and want to ask questions. And I thought that for those who are in doubt, this training is not an act of favor or punishment. We just want to be enlightened as to have a window into the way in which the mind of the next Chief Justice of Nigeria works. So for Kalu, I needed to understand that we are not doing her any favor by saying, take a bow. In any case, that has been settled. I just want to ask one or two questions. You know, my Lord, when we complain of crowded court, the courts only adjudicate based on the judicial confined on it by Parliament. For example, when my case went to court as a governor or governorship dispute, the law then was that cases are terminated at the Court of Appeal. The National Assembly, in its wisdom, chose to remove that bar and said the cases must now terminate at the Supreme Court. So we can't overload a vehicle and then blame the driver for carrying overload. But there are a couple of issues that I believe many of us distinguished senators must be aware of. That depending on the party you belong, at the level of the state judiciaries, people tend to prefer, talking about forum shopping, to file cases before Federal High Court, particularly if it's a case in which you believe the state governor or the state government may have an interest. And how we deal with this, how the Chief Justice of the Federation can encourage judges in the states to show the same level of courage to pronounce where it's so discovered that a state government or a state interest, a state governor has crossed the red line. But people should feel able to go to a state high court and get justice. I don't want to rush to federal high court because of the fear that judges, in many cases at the state level, don't want to enter judgment that will be offensive to the state executive. That is recently in the state, and for obvious reasons, I won't mention the state. The National Judicial Council approved the appointment of new judges, which is in line with the Constitution. But the state governor in Benin decided, I didn't mention him, I mentioned a city. The state governor in Benin refused to swear in. Excuse me.
You are protected. You did not mention the state. You only mentioned Benin.
Thank you, Mr. President.
Benin is not a state.
That's right. So, as we speak, those judges were not sworn in, even though they have been cleared by the National Judicial Council. When I was a governor, sir, there was a case, a judgment against the state government. But because the governor has immunity, the judge decided to sentence, to convict the Attorney General for contempt of court. So I'm like, if a state governor disobeys a ruling of a superior court, and because the governor has immunity, there is nothing you can do, I would have expected that the Attorney General will be charged for contempt of court or showing disrespect to the National Judicial Council, so that the discretion we exercise should not be abused to the extent that all of the processes that the National Judicial Council goes through to select and approve and forward to the governor for ratification. I am sure, Mr. President, you approve many such recommendations, not necessarily because you like the persons, but in the wisdom of the National Judicial Council, they've cleared them. So I thought that there might be, like to know how, whether a legislation is required or the Supreme Court, being a policy court, what it can do to help to curtail abuse of power at the level of the state. And lastly, there was this case of Mr. I don't know whether I should mention his name, a guy who was sentenced to 3 years in prison, up to the Court of Appeal. And the Supreme Court found that this was a criminal case that has to do with somebody who operated or officiated at the, I believe, MPA. He served all of the 3 years in prison. And then the Supreme Court found that he was wrongly convicted. The only benefit he's got is that he cannot now be referred to as a convict, but he suffered the punishment for 3 years. In such cases, where the lower court has misapplied the law, and a citizen has been sentenced to prison and served the whole of the 3 years, or even 5 years, is there a way in which the Supreme Court can order compensation for victims that suffer such humiliation for an act for which they were never guilty? And each time I see the guy on television, I wonder how he feels that he was in prison for 3 years, and the Supreme Court found that he was wrongly jailed, and yet he has suffered it and there are no compensation. I would have imagined that the court can award compensation, huge compensation, not the type that is not even enough to pay the cost of a senior advocate, but one that will also fairly compensate the victim for the period he spent in jail wrongly. Thank you, my Lord, and I also want to congratulate your family, because having seen that you serve in virtually all the jurisdictions, north, south, east, west, that means that for most of the time, members of your family were alone. And so for you to accomplish this, I think members of your family deserve commendation as well. Thank you, Mr. President.
Negative perception of judiciary. Mr. Nominee, in the event that this hallowed chamber confirmed you as the Chief Justice of Nigeria, what do you intend to do to reverse the negative perception of judiciary, particularly if you read Nigerian newspapers, even though perception is different from reality? But I think it is important for you and for us to really address this issue. Justice delivery is a problem in Nigeria. You see people that are arrested, put in prison, and some of them spend 3-4 years. And even if they are convicted, they may not be convicted for more than 2 to 3 months, but they end up spending 3 years. And that's why we have terrible prison congestion in this country. So this negative perception, how do you intend to really reverse it? Lastly, Mr. President, the Supreme Court made a very important judicial pronouncement. And this judicial pronouncement was commended by even the National Assembly. The Nigerian press, as negative as they are, as critical as they are, about the local government funds. With your permission, Mr. President, let me quote Section 287. The decision of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons and by courts with subordinate jurisdiction to that of the Supreme Court. So, end of quotation, Mr. President. Nominee, what do you intend to do to enforce the judgment made by the Supreme Court on local government funds that are supposed to be released directly to the local government councils instead of local government joint account? And to be honest, distinguished colleagues, the present insecurity Nigeria is facing is simply because local government have been deprived of these funds. So it is important for the Supreme Court and for all courts in the country to enforce that judgment. I so rest my case, Mr. President. Thank you.
Thank you, Mr. President. Sitting as chair, let me also join millions of Nigerians and my distinguished colleague in celebrating and congratulating Justice Kudirat Olatokunbo Kekereekun, who is the acting CJN of the Federal Republic of Nigeria. Mr. President, distinguished colleague, my question is very straightforward. Recently, there have been some interference in the appointment of judicial officers. Good example, what is currently happening in Osun State. My question is, how can the current process be improved upon without any controversies? Thank you.
Justice of Nigeria. My question is just straightforward. With your experience and the resume we have seen, you are fully qualified for this office, and Nigeria will need you. And part of that is that we have been having issues between states and federal government, or between the three tiers of government. Now that we are working on reviewing the Constitution of the Federal Republic of Nigeria, is it possible to think of having a constitutional court that will be handling these issues, and also issues related to electoral matters? And lastly, we have a lot of issues on terrorism in this country. So many times there have been arrests, but hardly we have seen such a huge number of arrests going vis-a-vis with adjudication. So I want to know if it is possible for us to have special courts that will also handle cases of terrorism like is being done in other countries. Thank you, sir.
Distinguished senators, our guests ably led by the incoming CJN. Sir, I speak on the side of first, as a deputy, I represent the good people of Plateau South and the deputy chairman committee on judiciary. I'm also speaking as a former governor. I know why I'm saying this. Mr. President, my question to the CJN, when you talk about autonomy, when you talk about independence, you are also talking about autonomy. I happen to chair the committee that on the side of governors that was fighting for the issue of autonomy and independence for the judiciary. We took the steps and we got up to Supreme Court on one aspect. My concern was that aspect that was rejected by the Supreme Court, and that has to do with the capital component. In other words, we are saying that they should, when you are taking charge of autonomy, you want to be autonomous, you must also be autonomous in all aspects, including capital projects. But surprisingly, we took the matter up to Supreme Court, and the Supreme Court rejected it. rejected autonomy. I say this because when we are talking about my interpretation, not as a lawyer, as a politician, is that when you are talking of autonomy, independence, you must carry everything. It must all be inclusive and also bear the consequences. And so I'm asking my Lord, do you still stand by that, or there is need for reconsideration? Because capital infrastructure is very, very important. It's very, very important if you want to be independent. That has gone, and I'm sure Her Lordship was on that panel, if not presided over that panel. So you are now the CJN, and I have concern about this capital infrastructure, because without it, there is no independence. There is no independence, and so you cannot be absolutely be said to say that you can work without influence from outside.
Thank you.
That is my.
And also, not just to congratulate you, but to adopt and possibly second what has been said from the first speaker, our Deputy Senate President. Looking from your resume, mine is a very simple question, and it is more like a summary of all what has been asked you. Asked by of you today here, is how can you, I want to emphasize that word, access to justice. In your own opinion, you've been practicing for so many years now. There are certain areas you believe needs to be improved upon. There are certain things even those of us from the parliament here can also do to improve on you doing your job better in guaranteeing or improving the access to justice. Thank you very much.
Wearing the golden crown of the people of Ebonyi North Senatorial Zone of Ebonyi State. My Lord, the CJN, I have to address you as such because equity regards has done which ought to be done. And this Senate does equity. My Lord, I will bother you with one question, which I have seen as part of our social problems in service delivery to Nigerians. My Lord, it is tried to say that today, bail is not free for Nigerians in all our police stations. I say so because in the course of the submission of Mr. President, he said upon the shoulder of the CJN rests justice to all Nigerians. And that is the beginning of serving Nigerians with justice. My Lord, I want to know, is there anything you can do differently by way of practice directive to stop these exploitations of Nigerians in our police stations? It's a fact that speaks for itself. Some of us that were in legal practice before now have seen it and it's happening, and nobody can deny it. Is there anything you can do as the Chief Justice of Nigeria to guarantee the rights of Nigerians under investigation at the police stations? Thank you, my Lord.
Distinguished Senator.
Distinguished Senator Ekong Samson, Akwa Ibom South. I will address the issue of the need for substantial justice and whether there must be compliance with laid down, the issue of substantial justice and technicalities. Over the years, we have emphasized in our judgments about the need for courts to promote substantial justice over technicalities. However, I believe that sometimes there's a misconception on what constitutes technicalities. Because we have rules, we have laws, we have precedents that we follow. And where a precedent is followed, it will not be correct to say that the court has enthroned technicality over substantial justice. All courts are admonished all the time to eschew technicalities, but it's not in every instance that matters are decided on technicalities. At the same time, where the court looks at the case before it and decides based on the facts and the application of the law. Sometimes the application of the law to the facts might appear to be rather technical, and this is why we also have the appellate courts who can correct errors where they are made. On the issue of elevation to the Supreme Court, I will crave your indulgence to leave that question for a different forum. Distinguished Senator Adams Oshomole from Edo North. You talked about the crowded courts dockets and the position where at a point in time matters terminated at the Court of Appeal, later on moved to the Supreme Court, and then the difference between cases filed at the Federal High Court and cases filed at the state high courts. What I would say is that it is the legislature that enacts the laws that confer jurisdiction on the courts. And therefore, anybody who has an option to go to either the Federal High Court or the State High Court is entitled to utilize that option. At the same time, where cases are decided, where it appears that a certain side is favored, the appellate procedure is there. And I think that is the only way we can curb it, unless there is clear evidence of bias or any inducement, corruption, or anything like that. But other than that, whatever decisions are given, the option is to go on appeal. And if you can satisfy the appellate court or the Supreme Court that the court concerned was swayed by other considerations, then the court will give whatever judgment is applicable in the circumstances. Now, on the appointment of new judges, the situation where judges have been recommended for appointment and they have not been sworn in that instance, the National Judicial Council has made its position very clear, and it is the National Judicial Council that gives the directive for who should be appointed. And once that is done, there is nothing more for the National Judicial Council to do. It is to the detriment of any state concerned if it is now working with a lower number of judges, and you have capable and already confirmed judges that are not being able to carry out their duties. It is not a matter that the Supreme Court can intervene in unless a matter is brought to the Supreme Court on that issue. The issue of compensation for a person who has served his time and found to be not guilty, can the Supreme Court order compensation? The Supreme Court can only decide on matters that are specifically brought before it and grant reliefs. And where there is no legislation that gives the court that power or that authority, there's nothing the court can do. At best, the court can just make an obiter comment on it, that this is a situation where, in ordinary course of things, this person ought to be compensated. But it's not for the Supreme Court to unilaterally make such an order, because everything we do has to be based on the jurisdiction that is conferred on the court. Distinguished Senator Abdul Ningi from Bauchi Central, you asked for assurances with regard to ex parte orders and an issue of ex parte orders prepared in advance, whether the hands of the judiciary is tied, and whether there should be legislation against the grant of ex parte orders. Now, the situation with ex parte orders, where it is, you see, in order to have the judiciary that we desire, we also need to be able to follow through on certain issues. If there's a situation where a judge is found to have ex parte orders prepared in advance, such a judge should be reported to the NJC and necessary action will be taken. It is not fair, even on the judiciary, when these allegations are made and nothing is done to substantiate them or to follow up on them. And we know that even when petitions are filed before the NJC, in some instances, you find that the petitioner comes back and withdraws the petition. So it is important for the NJC to be able to exercise its own powers, that these sort of matters are brought to its attention. And then the grant of ex parte order is discretionary, but there are guidelines. So where a judge is found to have ignored those guidelines, to have acted without due regard to proper process, or even the facts of the matter, then the necessary action will be taken once it is brought to the attention of the National Judicial Council. As I've mentioned, the code of conduct will be strictly enforced, and judges are admonished not to grant ex parte orders indiscriminately. So it's an act of misconduct. But at the same time, it would not be proper, in my humble opinion, to enact a law that does away entirely with ex parte orders, because they are necessary in certain circumstances. Distinguished Senator Ofowe from Bayelsa Central. Pardon? Ombowe, I beg your pardon. I want to believe that his question was rhetorical, and I have, I think, the permission of His Excellency to pass it over about whether who are those corrupt people. Then, Your Excellency, your question: should judicial officers allow social media to influence their decisions? Certainly not. We have taken an oath of office to carry out our responsibilities without fear of favor, affection, or ill will. So whatever is in social media definitely should not affect the way we make our decisions. However, it is true that there is a lot that goes on social media and other fora. And this is one of the aspects that contributes to the negative perception of the judiciary, because you have narratives out there that have no correlation to the facts that are before a particular court. And again, whether they are senior members of the bar or other members of the bar, there are procedures. A senior member of the bar who has earned the rank of silk, it's a privilege. It's not a right, and that privilege could be withdrawn if it is abused. So in any of these situations, the courts too will use their own powers. We do have powers where a matter is sub judice and somebody goes out in public on the television station, media, social media, to comment on those cases, because it does have a negative effect on the administration of justice, on how we handle our cases. Because when you then give a judgment, the way it is assessed is based on what has been in social media. But notwithstanding that, I would say that judges know the oath they have taken and will abide by that oath and not be influenced by social media. Thank you.
My Lord, you were very political in the last